He was with the majority last term in 94% of all the cases. This is not very often a closely divided court. For the third year in a row, he was with the majority in all of the most significant cases. Last term, he was in the majority in every one of the 31 constitutional decisions but one. I'm going to talk 30 out of 31. I'll talk about that case, a case called Bullcoming. You'll remember the name of it very, very soon. And he was with the majority, and this, I think, is the most telling point. In every constitutional or constitutional-like statutory decision that split the court between the four liberals, and they are, I guess in order of seniority now, Justices Ginsburg, Breyer, Sotomayor, and Kagan, and I'll amplify that later, and the four most conservative-leaning justices. And they are, beginning with the chief, I guess, then you have Justices Antonin Scalia, Clarence Thomas, and Samuel Alito. He was with the majority in every one of those 5-4 decisions, conservative or liberal, that split him into those two traditional groups. What was the exception? It's interesting, because there they didn't split between, in this case, Bullcoming against New Mexico. It wasn't a great big case. It involved an interpretation of the Confrontation Clause. And the question was whether the person who prepared a blood alcohol lab report, lab technician of some sort, has to testify if a report is introduced at a criminal trial. Does he have to come in and be available for cross-examination? Even though, they put it in, they give a report about what happened. The court split 5-4, and they said, yes, he does. It's a violation of the Confrontation Clause. All right? You want to know how but here's the way the breakup was. It was made up of the ideological extremes of the court. The five were made up of Justices Scalia, Thomas, Ginsburg, Sotomayor, and Kagan. Those are the extremes of the court. All right? The dissenters were, and I call those five the purists. They take a look at the Constitution. They say, this is what the Confrontation Clause was about from the beginning. Anything that was significant, that you have testimony at a trial, you got to have an opportunity for cross-examination. And the four dissenters are what I call, this was not liberals versus conservatives, it was purists versus pragmatists. And the pragmatists are Justices Kennedy and Breyer, and used to be joined by Rehnquist and O'Connor, and now by Roberts and Alito, their two successors. That's a footnote, really, to what I'm saying, 30 and 31. But just out of 31 anyway. But Justice Kennedy, he is plainly the strongest of the liberals. 30 out of 31 cases, that was the one he lost, right there. Kennedy is also, interestingly, the strongest and most consistent defender of free speech on the court. As a conservative, he's a conservative-leaning justice. There's no question about that. This past term, similarly to others, he was the only justice in a majority in all 6 cases involving the First Amendment. Whether they reached conservative results or liberal results or what have you, including 3 of the 4 most significant ones, all 3 of those finding a First Amendment violation. I'll talk about those, all right? Although okay. The first was the military funeral case called Snyder against Phelps. It's a group who paraded with signs on a street near the funeral home saying some really ugly things about God favors dead, military, and so forth, and all sorts of things, okay? The question was whether that was protected by the First Amendment, and the court held in an 8-1 decision that it was a violation of the First Amendment, written by Chief Justice Roberts. A very narrow and not significant, or at least significant in terms of precedent case, limited to the facts. He emphasized that, first of all, the parade, the demonstration, was not visible to the father who brought the civil suit, all right, who brought it during the funeral. They only learned about it on television afterwards. That the protesters had complied to the letter of the ordinance regulating protests in the jurisdiction and things like that, all right? Not a great precedent. Justice Breyer joined the majority, but only in a concurring opinion, limiting it even more, emphasizing certain facts altogether, saying we don't have to decide. And I want to say more about that later, about Justice Breyer. And there was one dissenter in the case, and that was Alito. The second year in a row, he was the lone dissenter in an 8-to-1 First Amendment decision. The one 2 years ago involved what they call animal crush videos. I don't know if you remember that. There was a ban on depicting cruelty to animals on a video. Well, I don't know what cruelty. For example, killing animals or dog fights and stuff like that. The second case was a campaign spending case called Arizona Free Enterprise against Bennett. It involved an Arizona statute, fairly detailed, but it's not hard to understand. It gave public funds to political candidates, as a few states do. The city of San Francisco certainly does. And they found that when the expenditures of a wealthy opponent of one of the candidates, when the wealthy opponent's personal expenditures combined with the expenditures of independent groups that were supporting that candidate, that when that happened, then the state of Arizona gave more funds to try to continue a level playing field to the less wealthy candidate. The court held unconstitutional, 5-4. It burdens the First Amendment freedom of speech, and that's consistent. That's all of the campaign finance spending decisions are like that. You cannot create a level playing field in a political campaign. Spending, money is speech for these purposes, and it's protected by the First Amendment. It's the usual 5-4 split on the court, all right? Justice Kennedy with the pro-First Amendment people. It's not surprising because, first of all, it's quite similar to about a dozen cases that we've had in the last 5 years, 6 years, 7 years maybe, in which the court has come out that way. And secondly, it was almost a dead copy, an exact copy of a federal statute that they struck down several years earlier. Note, it was a 5-4 decision. Who made up the 5? Justice Kennedy and the 4 conservatives. The 4 liberals dissented. Now that's a flip-flop. Here you have the conservatives voting in favor of the First Amendment, the liberals voting against it. Why? This is an economic case. That is a very strong exception, strong illustration of the exception to the notion that liberals always favor individual rights and conservatives don't. Quite the contrary. Flip-flop. 5-4. Another one was Brown versus Entertainment Merchants Association. That is the violent video games prohibition in California, struck down by the Supreme Court as a violation of free speech, 7-2. Interesting, so far as telling you the story about the justices are concerned. Who wrote the opinion? That arch-conservative, Justice Antonin Scalia, in favor of the First Amendment. Joined by whom? Justice Kennedy. He's always in there for the First Amendment. Rich or poor, conservative or liberal, he's the most consistent defender of the First Amendment on a court. And it was joined by Justices Ginsburg, Sotomayor, and Kagan. Once again, you got 2 conservatives, 3 liberals on that case. It was a 5-4 decision, but it really wasn't in terms of doctrine, because the other 2 in the majority were Chief Justice Roberts and Justice Alito. They had a very limited concurrence. They said the California statute was void for vagueness, but they said we're not passing on the fact that you cannot make these things illegal. Justice Scalia said, no, you can't. It's true we've cut an exception for pornography, sexually related materials from minors. But this is the First Amendment you're asking us to cut exceptions to, and that's it. We're not cutting one for violence, all right? So it really was a 7-2 decision, 5-4 decision. 5 of them saying you can't do it, period, but 4 saying yes you can if you do it right, All right? The two dissenters, interesting. Justices Breyer and Alito. All right? There you are. One liberal, one conservative. They are the two weakest defenders of the First Amendment on the Supreme Court, on a free speech provision. Note Justice Scalia. He continues to defend free speech when he finds that it's inconsistent with the original understanding, which, of course, is his, signature approach to the resolution of constitutional issues. For example, he voted in favor of the First Amendment when the question was, does flag burning violate freedom of speech? And it was held, they held, with his vote and with Kennedy's, necessary both votes, in order to constitute a majority. He often tells a story about it. He said his wife, who I think she shares his political views, came downstairs in the morning for breakfast, and there was the Washington Post, court strikes down flag burning prohibition, and she's there giving him breakfast and humming, "It's a grand old flag," and so forth. So anyway, she didn't like the opinion. That is, those are the three First Amendment cases. But let me just sum up to here. What appears to be clear from the discussion altogether, mostly about Justice Kennedy, is that the Supreme Court's two blocks, 4 solid conservatives and 4 solid liberals, is more hardened, or in a term that was used by Justice Breyer in a talk after the end of the session, polarized, more polarized since the days of Franklin Roosevelt and the New Deal 75 years ago. Now that does go back 75 years. You have a very hardened split on the court. And it's maybe more than ever split into these two hardened blocks. And I should say it extends beyond constitutional cases into constitutional-like statutory ones to other pure regulatory cases. And the conservatives usually win on all of these. Class actions are 2. I mean, that usually separates liberals from conservative justices, and liberals from conservatives generally. The Walmart case and another case involving AT&T, involving class actions and arbitration. I better not get into that because that's it. I've told you everything. I get one of these cases. Oh, no, next. You got to get through these things. So, anyway, and there's other cases involving bankruptcy, insider trading, Freedom of Information Act, preemption, and so forth. Okay, so.